Thanks everybody for being here today. This is Emerge Law Group's 8th deep dive webinar covering the Oregon Psilocybin Services Act. Today, we're going to be talking about the Oregon Health Authority's recently released second round of draft rules. With me today, we got Dave Kopilak. He's a seasoned business lawyer, familiar with all aspects of business transactions, financing, and corporate issues. He was the primary drafter of Measure 109. I'm also here with Corinne Celko. She's an experienced land use and real estate lawyer. She's dealt with all manner of development projects, local government issues, and regulated businesses. We've also got Alex Berger. He's our regulatory lawyer. He's an expert on interpreting complex rules, and he's also experienced with local government land use issues and regulations and how they affect regulated businesses, especially cannabis and alcohol, and now psilocybin. I'm also here with Kaci Hohmann. She's a business lawyer, and she was also part of the Measure 109 drafting team. And my name is Clancy. I'm also a business lawyer, and I specialize in intellectual property. And I, too, was part of the Measure 109 drafting team. So as usual, we are recording this webinar today. We're going to post the speaker presentation on the Emerge Law Group YouTube channel. We don't, however, intend to use any audio or video once the Q&A session starts. So anything recorded before the Q&A may end up on YouTube, but once the Q&A starts, we're not going to be posting that. We like the Q&A to be conversational in nature and a safe space to discuss the Oregon Psilocybin Services Act and these new rules. So please be open to viewpoints expressed today and be respectful of others. Please mute yourself unless you're speaking. We don't anticipate having to use the mute function on your microphone, but we can do that if we need to. We allocated 2 hours for today's webinar, so we can have an extensive and lively Q&A. Kaci's going to be monitoring the questions and comments, and she'll be able to call on you to speak during the Q&A session. Again, that'll be occurring after our sort of an opening speaking. When you have a question or comment, what we'd like you to do is, there's a few kind of options. One is you can type in the chat box that you have a question or comment, and then Kaci will keep that in her queue. Or if you have a short question, feel free to just type it out in its entirety in the chat box. You can also raise your hand using the reactions button here on Zoom, or you can raise your hand on video too. That works too. Don't be shy, please, about appearing on camera. It's more fun when we see your face and hear your voice when we're having these conversations. And when asking questions, please try to avoid asking fact-specific questions. We're not acting as anybody's attorney here today. We're not giving specific legal advice. We're just trying to provide information for general educational and informational purposes. If you're camera shy or if we run out of time, feel free to email us at m109@emergelawgroup.com. Kaci also dropped that address in the chat box. You know, with that said, I'd like to talk a little bit about today's webisode. It's kind of special because these rules are hot off the presses. They've been public for barely a week. They're voluminous, they're complicated. They interact with previous psilocybin rules and the Psilocybin Services Act statute, in addition to, of course, all the other Oregon laws and rules and regulations. So as you know, Emerge has been advising clients in the cannabis space for almost a decade, and we still to this day have debates about some of those rules, and those rules are still to this day being modified. So we're kind of in a position that many of you might be sort of soaking up a lot of this information. So some of what you're going to see today is us putting our collective heads together to think it through. Based on our understanding of the rules, we have had some time to go through and discuss them and read them and analyze them. But this is an exciting time because there's going to be a lot of questions that haven't been asked before. So you're going to see a little bit of legal analysis on the fly here. We're going to be running down new issues, reacting live to some of the questions and analysis. So I guess just to qualify, what we're offering here. And the exact wording and interpretation of many of these rules might change too. These are draft rules. There's still going to be rules advisory committee meetings and public comment period. So they will change. But with that said, we're expecting and encouraging a lively participation in the Q&A and looking forward to it. So I'm going to get us started, and given all the rules, we've kind of had a conversation about where to start, and we're actually going to start with psilocybin products. And what I wanted to do is to sort of try to orient everybody within the system by going through essentially the supply chain. to see sort of how this works. The system is built around the conditions where psilocybin is allowed. As many of you know, there's only one species allowed, Psilocybin cubensis. So this all starts in the psilocybin manufacturer. The psilocybin manufacturer is one of the licenses. Psilocybin manufacturer starts with mycelium and fruiting bodies. That is called a cultivation batch. They can then harvest it into 1 kilogram batches of dried whole fungi from the same 24-hour harvest. So you go from cultivation batch to harvest lot. A harvest lot, once it's dried, can then become a psilocybin product, or it can be processed into homogenized fungi, which is just what it sounds like, homogenized, made to be homogeneous, or it can be processed into an extract or an edible product. Each of these psilocybin manufacturers has to have an endorsement for the different type of product activity it performs. So we've got either the fungi cultivation endorsement, the psilocybin extraction endorsement, or the edible psilocybin production. So once the products are created, a sample has to be tested by a laboratory license representative. The laboratory license representative is the one who has to collect the sample and bring it back to the laboratory for potency testing. That potency testing is required for every completed harvest lot or process lot. Assuming a past testing, every psilocybin product, whether it's whole fungi, homogenized fungi, psilocybin extract, or edible psilocybin products, has to be packaged 1 serving per package with a 25 milligram psilocybin maximum per serving. Each package has to be labeled for clients, and I put the little rule there for what's required to be on each label. That has to happen before transferred to a service center. The products go from manufacturer to service center, and then a licensed representative of the service center is the one who can then transfer it to a client for the administration session. That could be a facilitator, but it doesn't have to be. So whether or not the facilitator is in the sort of chain of title of the product is, it's optional. Additionally, the client is required to be provided what's called a product information document, which is describing what the psilocybin product is. That has to happen at the preparation session, which occurs before the administration session. So it's kind of an overview of the different moving pieces of the supply chain, sort of hopefully helping orient people that are more or less familiar about the different places where psilocybin flows in this whole system. And sort of giving us a sort of landscape for what the different activities we're going to be talking about. Within the psilocybin product rules, there are a few issues that I, in going through it, wanted to bring up and point out. So the one is, of course, many folks know this, there's one species that's allowed, Psilocybin cubensis. That's definitely a limitation that was intended, I think, for more uniform initial activities, so there's more predictability. Unique ID tags are required for each of these steps along the way. So there'll be lots of ID tags being sold that will increase costs. One of the big issues that I've noticed and latched onto and heard discussion about a bit from some of the advisory board meetings was that there's a 1 package, 1 serving maximum based on milligrams of psilocybin. So that means that even for dried whole mushrooms, they have to be labeled based on milligrams, not grams of weight, but milligrams of psilocybin. And so that is something else that will likely increase costs. Dried mushrooms have variability in their concentration of psilocybin. So that will potentially be challenging also to the extent that there's variability in a harvest lot of whole fungi. Somehow to try to reach a reliable, useful measure of milligrams of psilocybin might be a challenge. And additionally, packaging those individually will result in lots and lots of packaging, lots of additional labor costs to accomplish that for each of the different labor types.
or different product types. It seems likely that there's going to be an incentive then for people to lean towards processing psilocybin, getting into homogenized fungi, psilocybin extracts, and edibles, because being forced into having this milligram psilocybin measurement and single servings, I think it will pose challenges for folks trying to just grow dried mushrooms and leave it at that, because of the potential changes in potency testing. The labels that are required, those will be seen by clients. It's a requirement that clients see them. So that's something.
It will be an opportunity for manufacturers to include not just information, but maybe tell a story or identify things about their business that they want clients to know about. And that information form is an opportunity for psilocybin manufacturer licensees to present information to clients and maybe tell a story, and to really market their products. I can imagine a psilocybin product catalog being presented to a client at their preparation session, and they could flip through with their facilitator and see the different options for different psilocybin products. The 1
kilogram per harvest lot, that will also be a limitation. I know cannabis actually changed the harvest lot size recently. I've spoken to producers who've already benefited from that change, because it's sort of,
rather than having to make many small harvest lots, they're able to do one large one, which cuts down on labor costs by limiting the size of a harvest lot to 1 kilogram. That will increase certain labor costs to the extent that there are more harvest lots that need to be bundled into that size. I talked about that 25 milligram packaging requirement. That's an issue, to be sure, in testing. I think there's also, I mentioned the product information document. I think there's also maybe some room to identify who's responsible for presenting that information. It seems like it would be within the preparation session, but because it's required to be presented during the preparation session, I think there's a potential issue if a client wants a different product during the administration session. If that product information document wasn't presented before the administration session, whether or not the client would be allowed to try that product. So those are some of my initial takeaways. I know there's a lot of rules, and so I'm going to pass it on to Alex to get into some of the next ones.
Thanks, Sean. So the first thing that I'm going to talk about here is relates to licensing. There were a couple of issues that jumped out at me in the new proposed rules regarding just the licensing process. The first is the fees. Frankly, I was a little bit surprised at how high the fees are, at least as compared to OLCC cannabis licenses. So in the rules, OHA is proposing that an annual fee for a manufacturer, service center, or lab license is $10,000. And then for a facilitator license, that they're proposing $2,000. And that is significantly higher than, the highest cannabis license fee, which is $5,750. So that represents a fairly high barrier to entry for some folks. Reduced fees are available according to the proposed rules, but only under very specific circumstances. So if one applicant for a license or an owner of a licensed business is an SSI recipient, registered with the Oregon Health Plan, a food stamp recipient, or a military vet, then those fees are cut in half. But nevertheless, those fees do seem quite significant, especially for a facilitator. Some folks in those categories may not be able to easily afford $1,000 a year to be a facilitator. Another issue that jumped out at me is the definition of what's called an applicant. So an applicant is basically who OHA will hold responsible for the conduct of the licensee. They are also jointly and severally liable for violations, for administrative violations. And OLCC is OHA is proposing to define an applicant as a person or legal entity that controls or holds 10% interest in the licensed business, or is entitled to 10% of the profits, revenue, or proceeds of the business, or has direct control of the business. And then anyone who is considered an applicant must be disclosed upon application, must be fingerprinted for a background check, and ultimately approved by OHA. And that 10% threshold strikes me as pretty low. There may be a number of investors out there or owners of businesses who want to get into the psilocybin industry, but don't necessarily want their names to be associated with a license, or are uncomfortable with being fingerprinted, or with disclosing their names. And also, such a low threshold means that quite a few owners OHA will have to process and vet quite a few folks, which could increase processing time between when an application is submitted and then hopefully approved. To compare with the OLCC in cannabis, they started with a 10% threshold for applicant, but then increased it to 20% for the reasons that I listed. Also, interestingly, for existing licensees, OHA is proposing to require that adding an applicant or removing an applicant will require prior written approval by OHA. So again, they will have to vet anybody who wants to invest at a 10% or higher level, or will receive 10% of proceeds before that person can be added to the business. And so that could really slow down. You know, many businesses, we saw this in the cannabis space, needed a relatively quick influx of capital, but they were held up by long vetting processes. So it'll be interesting to see if that 10% threshold remains as these rules are worked through. Something else that I found interesting was in the rules that require requesting permission from OHA to modify your licensed premises. That makes sense from a safety perspective, because OHA should know, you know, if you're adding a building where psilocybin services are going to take place or something of that nature. But they're also requiring a licensee to request approval if there is any addition or change to a residence or other unlicensed structure located on the same tax lot as the licensed premises. So I can imagine a business operator at a premises on a very large tax lot, and they might not necessarily know who their neighbors are on that tax lot. But nevertheless, according to this rule, OHA is expecting the licensee to ask for permission before, you know, somebody else on that tax lot builds a house, makes an addition to a house, and I think that may be overbroad and possibly unworkable. But those are just the few licensing issues that I saw, and I'm going to throw it over to Kaci to talk about preparation sessions.
Hey everyone. I'm just going to quickly cover some of the interesting tidbits of draft rules that would govern preparation sessions. Before the rules came out, you know, we were concerned that a client may have to complete a preparation session before each administration session, which would have been very burdensome for clients and for facilitators. Luckily, that's not actually the case under the draft rules. A facilitator has to complete a prep session with every client who will participate in an administration session at least 24 hours before the client's first administration session. But after completing that first preparation session, there are no additional preparation sessions that will be required with the client for 12 months. And if different facilitators are going to conduct different sessions, so you have one facilitator conducting a prep session, one conducting an administration session, the client has to provide written consent for that, and they have to be given an opportunity to meet every facilitator that's going to be providing them psilocybin services in any session. There's going to be a pretty large volume of documents that have to be provided to the client and reviewed with the client during the preparation session. One of those is a Bill of Rights. The Bill of Rights includes a laundry list of rights that a client has, which are basically obligations for a facilitator or a service center regarding the treatment and protection of clients. It's got to be posted in a prominent area in a service center, and it has to be provided to a client during the preparation session. It's a really interesting document. It raises a lot of legal and liability concerns that we've been discussing as a practice group this past week. There are some likely repercussions for facilitators and service centers who violate the client's Bill of Rights. Violations can be reported to the OHA. So theoretically, the OHA could suspend or cancel a license or impose a penalty on the licensee. Violations could also be the basis for a lawsuit by a client. So failure to abide by the obligations in the Bill of Rights could result in legal liability for facilitators or service centers. Another document that isn't a surprise to see is an informed consent. It's basically just a document where the client acknowledges a list of items. So that includes acknowledging the Bill of Rights, the fact that psilocybin is not a medical treatment, potential side effects of psilocybin, things like that. There's also a client information form. That form has two categories of questions. The first category requires a client to answer yes or no to a list of questions. So that includes like whether or not the client uses lithium or, certain medical, mental health, behavioral health conditions, whether they've considered harm to themselves or others. A facilitator is going to have to review those answers and determine if the client qualifies for psilocybin services. So it's kind of like a red light, yellow light system. The OHA rules actually instruct facilitators what to do based on the client's response. So for instance, if the client responds affirmatively that they use lithium, that means the client can't participate in psilocybin services. Or if they respond that they have, certain medical or behavioral health conditions, then the facilitator has to encourage consultation with a medical provider. The second category of questions in the client information form are optional. They're narrative responses that a client can provide, but they're not obligated to. It includes a list of current medications, mental health history, substance use, past experience with altered states of consciousness, things like that. And a facilitator or service center could presumably expand the scope of those narrative questions. And under the statute, even though it's not actually provided for in the draft rules, they do have the right to refuse service for any reason. So a facilitator or service center could refuse service to someone for not answering those narrative questions if they wanted to. And there's a number of other documents that have to be provided and reviewed during the prep session. That includes a transportation plan, which Alex is going to discuss in a little bit, product information document that Sean discussed, documentation of certain fees, and a variety of written consent for certain things like group administration sessions, the use of supportive touch, use of different facilitators, things like that. So those are kind of the big things on prep sessions, and I'm going to kick it over to Alex to cover administration sessions.
Thanks, Kaci. So some issues that cropped up regarding administration sessions and the draft rules. One concept that I found interesting was the client support person. So typically at an administration session, you have a facilitator monitoring the client who consumes and then experiences the effect of the psilocybin product. But in the draft rules, there is also this client support person who may be present at an administration session, but only for specific purposes. And those purposes include helping administer a separate medication to the client, assistance with medical devices that the client may need assistance with during the session, hearing devices, or alternative communication device support, or assistance with the consumption of the psilocybin product itself. So that makes a lot of sense to me to sort of limit the liability of a facilitator when a client has needs outside of just what typically goes on in an administration session. But I was curious why the OHA seemingly chose to limit a client support person to those very specific circumstances. I can imagine that many clients may want to bring in a friend or a family member to provide sort of moral support during an administrative session, So it'll be interesting to see if that definition remains narrow or if it's opened up to allow more folks to act as client support people. I also found it sort of interesting how many, at least in the draft rules, how many facilitators and other folks will need to be available at a service center, even if there's only, you know, one administration session going on. For example, obviously there needs to be one facilitator, at least one facilitator per client, except for in the case of group sessions when there can be one facilitator for several clients, but obviously there needs to be at least one facilitator. However, there also needs to be at least one other service center representative available to monitor the client if the facilitator needs to go to the restroom for some reason. Also, under the draft rules, there needs to be a backup facilitator who must be available during the entire administration session and only 15 minutes away, which I could imagine would be difficult, you know, if there's a relatively remote service center somewhere, there needs to be somebody on call who can get there in 15 minutes. And my understanding under the draft rules is that that is the facilitator's responsibility. So the facilitator, the primary facilitator, is going to have to find somebody 15 minutes away, just in case something happens to the primary facilitator during the administration session. As I mentioned, there will be, at least under the draft rules, group administration sessions, but within that group administration session, every client is given the opportunity to leave the group and move to an individual session. So obviously for an individual private session, you will need an additional facilitator. So theoretically, if you have a group session with 10 clients and one administrator, or sorry, one facilitator, if every single client wants to move to an individual session, the service center will have to provide the space for that, and additional facilitators, which is ultimately going to increase costs for the service center and probably the clients. Also, with regard to the duration of an administration session, OHA in the rules set it up so that there is a ratio between the strength of the psilocybin product administered and the minimum length of an administration session. So on the low end, up to 5 milligrams of psilocybin consumed, the minimum length of administration session is 1 hour. And then on the top end, for between 35 and 50 milligrams, the minimum session length is 6 hours. And I've already received some feedback from some industry experts that those hours may be relatively short, and some people, based on those dosages, may be experiencing the effect of psilocybin in excess of those minimum administration session durations. Interestingly, also, according to the rules, after the end of the minimum duration, the facilitator and the client determine together whether the administration session is over or needs to be extended. And you can imagine there'd be some difficulties there in the case that the facilitator believes the session is over and the client doesn't. I mean, who has ultimate say? And that could result in scheduling difficulties for the facilitator as well. You know, if a facilitator schedules their next administration session an hour after the minimum duration of their first session, and the client insists on extending that session, then it could really screw with the facilitator's schedule. Lastly, I just wanted to talk about this transportation plan that Kaci mentioned. At the preparation session, the facilitator and the client need to agree upon a written transportation plan that describes how the client will safely leave the administration session upon completion. And within that transportation plan, the rules prohibit the client from using a motor vehicle, a bike, or a self-operated vehicle, quote, immediately after the administration session. So, you know, that begs the question on some issues, such as, you know, can a client sit around for a couple of hours after the administration session is ended and then they can operate a motor vehicle? The facilitator is allowed under the rules to use reasonable efforts to prevent clients from operating a motor vehicle immediately after the session. But does that include physical restraint, threatening to call law enforcement? You can imagine that a client agrees in their transportation plan to walk away from the location, but where to? I mean, across the street to a parking lot, to get into their car. So, you know, there are a lot of potential issues there with the transportation plan. So with that, I'm going to pass it back to Kaci to talk about facilitator scope of practice and standards of care.
Thanks, Alex. Okay, so scope of practice, standards of care for facilitators. Our firm has had numerous discussions during deep dives and on our blog and in public comments to the OHA's previous set of draft rules concerning facilitator scope of practice and standard of care and the merging of licensed professions with psilocybin services. And to be honest, we were pretty delighted with how the OHA handled those issues in the draft rules. First and foremost, I'll just quickly cover facilitator standard of care. So under the draft rules, facilitators have a duty to put client interests above their own and to use a standard of care that other reasonable facilitators would use under similar circumstances. To figure out what other facilitators would do under similar circumstances, an obvious place to start is the OHA rules themselves, which help govern what facilitators can and cannot do. And of course, the content and information that facilitators will receive during their training program will help dictate that as well. What's unclear is whether there will be other generally accepted standards and practices and where those would come from. They could come from similar industries or the underground or indigenous practices. But long story short, standards of care is something that's going to evolve over time as the market ages in Oregon. Facilitators also have to provide psilocybin services within the limits of their professional competence. It's a bit unclear what exactly professional competence means, but in general, I just think facilitators should try to remain aware of the client's needs and assess whether they're the best fit or if they should refer the client to another facilitator. Next, I'll just quickly talk about scope of practice under the rules. So scope of practice is defined in the OHA rules as practicing boundaries relating to facilitation and avoiding the unlicensed practice of other disciplines, including but not limited to medicine or psychotherapy. That definition is not actually used anywhere in the rules except in the header for Rule 5130, but 5130 basically reiterates the concept. It says that a facilitator can't engage in any conduct that requires additional professional licensure, including diagnosing or treating physical or mental health conditions, and they can't exercise the privileges of any professional license that they hold in another field while providing psilocybin services. This solves numerous issues related to the merging of professions that Emerge has been flagging for a long time. In practice, it just means that facilitators should be mindful of being non-directive, which is defined in the rules as taking an approach of maintaining a consistent disposition while avoiding giving direct advice or directly interpreting a client's statements or behaviors. And so if a client wants to engage their facilitator for directive type of services, such as psychotherapy, then they just need to do so outside of the context of preparation, administration, or integration sessions. And one way that facilitators can try to protect themselves against ordinary negligence claims for breach of a standard of care is to enter into releases from liability with the client. And those releases can just be part of the overall contract with the client. It should be given to the client for review during the preparation session, in addition to the other documents that are required by the OHA. And if the facilitator also holds other professional licenses, they should consider preparing a document that's signed by both the facilitator and client. It's given to the client during the preparation session, and it should include a disclaimer, something to the effect that the facilitator is not practicing their licensed profession while providing psilocybin services, and that the client's not necessarily relying on the fact that the facilitator is a licensed professional and choosing the facilitator for psilocybin services. And in terms of insurance for facilitators and service centers and manufacturers, The market will need general liability and products liability insurance, and those policies exist in cannabis, although they're often subject to many exclusions, and the exclusions for psilocybin services, maybe even more voluminous than they are for cannabis. Facilitators hopefully will have professional liability insurance, but all of this remains to be seen. And so I'm just going to kick it over to Dave now, who will cover the rest of the topics.
Hi, everybody. I'm going to quickly touch on two things, and then we'll probably open it up for some Q&A. I'm going to harken back to two of our prior webinars. The first one was, I guess, our first webinar back in January. We talked about microdosing, and way back then, I thought I said that microdosing if that's someone's business model or intended business model, it's probably going to be, legal in the sense that the only way it would not be legal would be for the OHA to have some minimum dosage requirement. You can't have an administration session with a dosage less than X. So we never thought that was going to happen. So the real question was always going to be, are all of the other rules that the OHA is going to come up with, is it going to make it practical for microdosing to be a business model? And that's a policy decision that would be made. And so when the rules came out, I flipped around 65 pages, and there's a number of rules that affect this. So, there's no minimum dosage requirements. We expected that. There's group administration sessions. Yes, we expected that. The 16-to-1 ratio, 25 maximum. So everybody could sort of saw those. But Kaci mentioned there's no need to have a preparation session for every single administration session. That was kind of good. You can have different facilitators. That was kind of good. But I think there's a couple things that just it seemed to kind of blow it out of the water. The fact where in a group session, any client at any time can presumably demand an individual session. So I think that not only affects microdosing, it seems to me like that significantly affects any group session. I mean, if you have a 16-to-1 group session, as I'm reading it, you need 15 other facilitators, not 15 minutes away, but sitting there waiting potentially for every single person to say, I'd like to be by myself under 5,200 with my own facilitator. So I think unless you've got some army of facilitators sitting there during administration sessions, which obviously would be crazy expensive. So I think group sessions, unless you're talking about a really small group, 2 or 3 or 4, group sessions and microdosing, that particular rule makes it almost prohibitively or prohibitive. It just, nobody's going to do that. The minimum duration of a session is an hour. Now that I thought to myself, well, that's, I get that. Even if you have some, sub-perceptible dosage, you got to hang out there for an hour. Okay, perhaps folks could live with that. Maybe that'll be reduced in the rules down to half an hour or 45 minutes or something. But that's another example of a rule that's going to sort of potentially impact the business model. Transportation plan and all this stuff. So to me, I think, looking at that, the one rule is the most, I guess, impactful, is the one where in a group session, it would seem to me, now maybe this is not the intention, but it would seem to me that as I'm reading it, that you have to have at the ready a separate facilitator for every single client during the entire session. So to me, that's makes microdosing impossible, not impossible, but not a viable business model, and makes any group session very questionable from an economic standpoint. Which and then of course, look, the whole thing. This is a great balancing act between safety and affordability and accessibility. And I thought there's a number of rules that where the OHA probably erred on the side of being safe, which is totally understandable. But from a business model perspective, we're just trying to figure out like what is permissible here and what is not. And that sort of plays into equity and a bunch of other things. Okay. The other thing I wanted to talk about just for a second is 280E, entity organizational structures, and that sort of subject. I in a previous webinar, I had thought that 280E can be very, very impactful here in a very negative way. All cannabis businesses deal with 280E. It is not that bad for manufacturers, for producers in cannabis. It is way worse for retailers. And I thought it could be way, way worse for service centers and facilitators. It's possible, but I had suggested several rules for to sort of give companies and entities the flexibility to kind of have different entity organizations, to have different things going on during the licensed premises when sessions weren't taking place. And I was very pleased to see that almost all of what I thought gave companies a lot of flexibility was there. So I won't go through all of the details, but I think that when setting up a service center, when organizing your entities, when figuring out who the licensee is, who's going to occupy the licensed premises at any particular time, I was very pleased at the various rules I saw there. So happy to talk more about that if anybody has any questions. But I see Mason and Rose and Sarah have some questions and comments. So you want to open it up, Kaci?
Sure. Yeah, I think, Rose, you were kind of firing away some questions first. Feel free to jump in and chat about whatever you'd like to.